Hi, Attorney Max Frizalone with FrizWoods, here today to answer some of the most common questions that I receive when I'm having a consultation with somebody charged with their first time charge of assault in the second degree. The first question I almost always get is, what is an assault in the second degree? Well, in Maryland here we have 2 degrees of assault. Felony assault in the first degree, which is limited to situations where a firearm is used, there's strangulation, or the person doing the assault has an intent to cause a serious bodily injury. And second degree assault, which is pretty much everything else. When I say everything else, the different ways to proceed on an assault include a battery, an attempted battery, a swing and a miss, or an assault with an intent to frighten. I'm gonna get you. Here's my knife. You get the idea. The next question I get without fail every time is, am I going to go to jail for my first time second degree assault? And the answer is, it depends. The first thing we need to approach in every criminal case is, can the state prove that assault that I just discussed with you beyond a reasonable doubt? If they can prove it, then the question becomes who, as in the judge, who influenced them to give you jail or give you a probation. If you're going to enter a plea or have a trial and are found guilty, some of the things a judge might consider when sentencing you are your prior criminal record, the injury of the victim, the wishes of the victim, if you've ever successfully completed a probation before, and what other mitigating steps you took ahead of court to show the court that you're not a danger to both the community, the other person, yourself. The next question I always get is, how do I get the charges dropped if the other person didn't press charges? The answer is, it's a state of Maryland versus you in a criminal case. So the wishes of the other person aren't always taken into account when we proceed into a trial. Now, the wishes of the victim could influence the state's decision to proceed in a case, but the victim themselves cannot forcibly drop the case, although there may be ways they can frustrate the process if that's their wishes. What kind of evidence is the state going to have against me? Some of the most common evidence in assault cases is testimony. The victim comes into court, says, the defendant hit me, the defendant punched me. A lot of people say that's just hearsay. In fact, it's not. Hearsay is an out-of-court statement offered for the truth of the matter asserted. Ben told me he saw the defendant hit him. That's hearsay, but Ben can come to court and say the defendant hit him. Sometimes we receive body-worn camera if there were police officers present at the time of the assault or afterwards. We might receive a 911 call, a witness statement, even surveillance footage. Every case is different. The last question I always get is, how do I get my assault charges dismissed? The answer is, again, it really depends. We could litigate pretrial motions, try to suppress statements you made or evidence that was collected. We could force a state into a trial they're not prepared for. There's a lot of different ways to have a case dismissed, but that's a very case-specific question. Ultimately, if you're charged with a second-degree assault in Maryland, the most important thing you can do is consult with an attorney. Feel free to give us a call if you'd like to discuss your case. Thanks.